Very good. I see Mr. Forgive me for mispronouncing your name if I mispronounce it, Mr. Pickin,
It's Pitchine, Your Honor.
Pitchine, and Ms. Westmoreland. Welcome, and Mr. Pitchine, we are ready for you.
Thank you very much, Your Honor. And if it please the court, good morning, Your Honors. Good morning, counsel. My name is Raymond Pitchine. I am the attorney for the appellant in this case, MJD. My client is an elderly woman who was institutionalized in a nursing home who applied for Florida Medicaid benefits under Florida's Institutional Care Program, ICP for short, to help pay for her nursing home expense. Her application was denied. And as you can imagine, that's what started the problems in this case. And there are two problems we'd like the court to address. They're not issues, they're real problems. The first problem has to do with the substance of this case, the substantive issues, homestead, and the amount of money that are in a person's checking account. Those are important issues for sure. But the second issue is more procedural, and it has to do literally with a single piece of paper and the appellee's answer brief. And this is where the problem in this case lies, and this is the problem we'd like the court to address. When you take a look at the appellee's answer brief, Your Honors are going to look at this and assume that everything you need to know about this case is contained within this brief. And there's actually three arguments that are made in this brief. One of them has to do with the homestead, which we've heard several times, and the record is clear.
Mr. Pitchine, let me ask you a question about the homestead. If the piece
Yes.
of property that's involved in this matter, in fact, does not qualify as homestead, does that more or less end the case?
It does not, Your Honor.
If it was properly found to be non-homestead property, wouldn't that then mean that the threshold for the benefits would be exceeded and you would be unsuccessful in this case?
It does not, Your Honor. There's actually two standards. There is a federal home standard, which the test for a home, which is actually what the hearing officer ruled upon, is actually a more liberal standard than the homestead. A person could have a home in Florida and not be its homestead. But for Medicaid qualification purposes, homestead you don't necessarily have to have homestead status in order to qualify for the ICP benefits. As the hearing officer pointed out, there is a home exclusion, which is actually a more liberal standard. It's actually an intent standard. There is no physical act that's required in order to establish a home for ICP.
So operating under the federal standard, what facts in the record did you all present that would have established this $400,000 residence that was purchased within 1-2 months of the application and was apparently never lived in beyond an overnight? What facts would establish this as a home under the applicable standard?
There is testimony in the record from the appellant's daughter, who testified that she asked her mother if she liked the home, if she wanted to live in the home, and whether she preferred to live in the nursing home or to live in that particular home. And the responses from the appellant were all consistent. I don't want to live in a nursing home. I want to live here.
Sure, and that may very well go to what your late client's state of mind was about this property. How does that tie into the applicable standard, which is what you have to argue here, that could be deemed a home, a person's intent to live on a property divorced from some other salient fact?
Yes, under the federal standard, the intent is very liberally construed. It literally can be a person who has power of attorney that says, that's my mother's home. It does, because remember, in this context, a person in a nursing home may not be able to communicate. So literally a power of attorney, a person who holds power of attorney, is sufficient under the federal standard to express intent. That's my mother's home. That's all that's required. That may not be required for homestead status. I agree that there is a use and occupancy test, and there is also an exception to that test that we've complied with. But under the federal standard, a power of attorney can literally stand up and say, that's my mother's home. And that's good enough.
I was under the impression there was a requirement that the home actually be occupied at some point in order to meet the standard. Am I missing that, or is that?
I don't see that in the federal regulations anywhere, Your Honor. I see in the federal handbook, it literally says declaration of that home being its home. It's like.
If you call it a home, it qualifies regardless of the fact that it was never actually occupied?
Yes, and when you look at the intent to return, let's say she lived in the home and went to the nursing home, her intent to return to the home is presumed. Now, if we're
So,
going.
Mr. Pichin, you would contend then that in paragraph 103 of the order that ultimately gives rise to this, wherein DCF found the home is any property in which an individual and spouse, if any, has an ownership interest and is bolded, which serves as the individual's principal place of residence, see 20 CFR section 416.1212 sub A.
Yes, sir.
You would say that was just an incorrect assessment of the law.
As far as the hearing officer is concerned, yes, because if you look at the definition of principal place of residence under the federal manual and the instructions given on how to establish principal place of residence, it's mere intent. That is
And
my
this
home.
manual is in our record?
It is, Your Honor, yes.
Where?
The citations to the federal manual is in the record, is in the brief. Yes, Your Honor.
Citations to it. The manual itself, though, is not in the record before this court, is it?
I believe the excerpts from the particular sections have been in the record. Yes, Your Honor.
You understand the distinction between the two, citing to something and then having it in the record?
I do, Your Honor, yes.
Okay.
And the issue with the homestead, Your Honor, there is a use and occupancy test. We understand that. But 100 years ago, the Florida Supreme Court has ruled that there's an exception to that, and that is the mere preparation of the home for residency in certain circumstances is enough. And in this particular case, we have to look at this in the context of a person in a nursing home. The only thing stopping her from living in that home is her health. And the reason why the intent to give someone a status as their home for ICP purposes, it's a very important issue, because you never want to find yourself in a situation where you walk into a nursing home and you say to someone who has lived in a home all their life and purchased a home knowing that they're going to be in Florida permanently now, and go to them in a home, in a nursing home, and say, Mom, Dad, sister, brother, friend, whatever the situation may be, you're in a nursing home. We know you don't want to be here, but we had to sell your home. That's a death sentence to somebody in a nursing home. It's an emotional death sentence long before physical death ever knocks on the door. That's why it is so important to preserve. It is, this woman in this particular case lived in a home all her life. Now, yes, she purchased the home several months before the application, but that was because, and it's in the record and in the testimony, her daughter had decided to remain in Florida permanently, and they weren't going to be going back to New York to go to a nursing home in New York. They were staying here. They were settling down, and they needed to purchase a home for their mother. They don't want their mother in a nursing home. They want their mother in a home. The mother doesn't want to be in a nursing home. She wants to be in a home. She has physical incapabilities that prevent her from doing that, and that should not stop her from forming the intent to have a home. If she had the home to begin with, her intent to return is presumed. How can we say she cannot have an intent to form that home in the first place? The greater issue in this case, Your Honors, is the fact that two of the three arguments that are raised on appeal are raised for the first time. And when you look at the notice that was provided in this case, and you take out all the form language, it comes down to one sentence on one piece of paper and says your assets are too high for this program. And that's it. That's not even a reason, that's a conclusion. And the reasons apparently for that denial are set forth in the appellee's answer brief. For the first time, nowhere in the record has anyone argued presentment of a check. Nowhere in the record has anyone argued that a procedural rule at an administrative hearing gives the state the opportunity to endlessly litigate, endlessly investigate, and endlessly change the criteria for denying an application. That's the greater issue we're dealing with here. We have a notice that says your assets are too high. Which assets? We don't know. We're not going to tell you. We had to have a 2.5-hour deposition, a trial, and an appellate proceeding to figure out what the reasons were. And those reasons changed all 3 times, including on appeal. We submit to your honors that if the notice requirements that are imposed upon the state, and there's 3 requirements: process the application in 45 days, give a notice that is sufficiently specific to tell the reasons why you're denying the application, not the conclusion, and have evidence in your file.
Right, where, and this goes to your first point on appeal, and it seems like the entirety of your argument on that first point rests upon your assertion that DCF is required, and I'm waiting for you to fill in the gap for me, required by something to provide what you're telling us is lay out all your reasons. Don't just tell us you're denying, don't just tell us too high assets, but lay out your evidence and your reasons, almost like a bill of particulars or a motion for more definite statement or something like that. Help me out. What is the require? Why do they have to?
There's actually 2 requirements. There's a federal requirement and a state requirement, and they're both in the federal regulations and the Florida Administrative Code. Those 3 rules, they're consistent both at the federal and state level. 45 days to process an application. Well, they did it in 30, they complied with that. Give a notice that's sufficiently specific to tell the reasons for the denial.
That's the part I want you to hone in on. What are you citing to? What can I look at? What can I read that tells me, yeah, this notice falls short?
There is a citation in the brief, Your Honor, to Florida Administrative Code section that deals with that specific issue. I can look it up in the brief. I don't have that specific. This is administrative code intensive case, so I don't have that committed to memory, but it is in the brief. Those 3 rules are in the brief. They're extensively in the brief, and the citations to both the federal and the state law are quoted extensively in the briefs. And
I'll just be candid with you, Mr. Piccin. I looked at this stuff and I couldn't make that gap. I couldn't bridge that gap between what you're saying, what you're contending is in there, and what I read. So that's why I'm asking for your help with this. You're
Yes.
saying that that they needed to lay out all of their reasons, give you specific, almost like what you would expect. For example, in a civil complaint, you have certain elements, you have to state them, you have to state the ultimate facts in order to state a cause of action. You're kind of making that argument here in this administrative proceeding, but I need your help to tell me what legal requirement compelled DCF to have to do this before they could lawfully issue that denial.
The administrative code section says state the reasons. If you look at the notice that was actually issued, there are no reasons.
Well, they said the assets were too high. That's the reason.
But that's a conclusion.
You're saying that's not enough, right? I get it.
No, that's a conclusion. That's literally a conclusion. If you take asset A, B, and C, you add it up, you're over the limit. That's a reason. If you say your assets are over the limit, and think about it, if they had expressed what the reasons were, we probably wouldn't be here.
Okay, and that ties into kind of my final question on this point, and then I'll let you carry on, which is one of the things we look at is what was their harm as a result of this. And whenever we look at an alleged lack of notice, that's one of the things we have to focus in on. I think you acknowledge you were able to take depositions. I know there was a little bit of wrangling going on with that. You could lay all of this out, the fact that there was oscillation going on with DCF's purported reasons before the hearing officer and then on appeal. How did this deprive your ability to present your case to the best of your ability for your client?
If you say to a client, if you say to an applicant, you have too much money in your checking account, and the applicant gave substantiation as to why that is, then you need to state the reason why that's invalid. And according to the answer brief, that reason is stated for the first time.
How did this cause you harm in your presentation of your case below?
If you're arguing that checks needed to be presented to a contractor in order to qualify that as an indebtedness, day one, if they would have said that, pay the contractor, case over. At any point in time in this proceeding, if they had said that, case is over. That's the harm. If we wait until appeal to tell us the reason, how do we resolve cases? The harm is we could have settled this.
Mr. Pichik, just to let you know, you did not reserve time for rebuttal. You've got 4 minutes left. Certainly you can complete your answer, but if you want to reserve any time for rebuttal, you need to let me know.
Yes, I'd like to reserve 4 minutes, Your Honor. And just to that last point, the harm is if you had told us the reason, we would have settled this case in November of 2019. And I will yield the rest of my time.
Very good. Thank you very much. Ms. Westmoreland.
Good morning, Your Honors, and may it please the court, thank you for your time today. The court's questions are well-founded, and the department would establish that the question to Judge Black's first question was, if the homestead is not deemed homestead, does it end the issue? And the department would argue that yes, it does, because anything over $2,000 in assets would end the issue for any particular case. However, there are 3 issues in this case, and that is the due process argument. And I will
Yes, one question about the homestead issue. If an individual is in a nursing home and they're somewhat out of it, but they have occasions of lucid, times where they're lucid, and they say, I want to die. I don't want to die in the hospital. I don't want to die in the nursing home. And the family says, well, you've got enough money. We're going to go ahead and get you a place, and we'll get you out of here, and you can pass when the time is appropriate. Would there be no ability for the family to acquire that home and have it exempt from the calculation for purposes of financial assistance?
The answer to that question is yes, but it would depend on 2 factors. Under the federal code and the plain language of the law, the principal residence is a home where you live. And the intent to return to a home is, as Mr. Pachin says, your intent to return to the home. However, you cannot return to a home in which you never lived. So if you're in a nursing home before you apply for benefits, then you have no home. If you buy a home before you apply for benefits and try to establish it as your principal place of residence, your argument fails because you've never lived in the home.
So a person in my scenario, in fact, let me make the scenario a little bit different. A person is in a long-term care facility, but there seems to be some hope that the person could be discharged. And so the family makes arrangements to acquire a property with the person's assets so they have a place. But then the patient takes a turn for the worse. So again, in that scenario, it's the department's position that because she never resided in that home, regardless of intent, regardless of desire, regardless of the hope that in fact she can be discharged, that it can never qualify as a principal place of residence and be accepted from the calculation.
Not unless they actually live in the home. So in your scenario,
That's the standard that the department is applying, that if the person never lived in the home, they cannot claim it as exempt.
that's correct. Because again, the federal law, the plain language is absolutely clear. I mean, Mr. Pachin would argue the Florida Constitution, but we have to understand that Medicaid is a federal program. It is voluntary for each state to participate in. And once they participate in the federal program, they are bound by the federal regulations. The federal regulations under 42 CFR 416 indicate that the home is an asset that the person owns and has equity in, and claims as and is established as their principal place of residence. And if they leave that residence, they have an intent to return. Therefore, the asset is excluded. You can't leave a residence that you never lived in. That's the whole point.
But one of the concerns, of course, is if we set out a bright line rule along the lines that you're saying, I guess I want to make sure that it applies in all contexts. So a healthy individual is going to move from New York to Florida. They purchase a home before they get here. They have a terrible car accident on the way down. They end up in a long-term care facility, may or may not ever be released, but the family applies for the benefits. Again, making certain I understand the rule that you're suggesting applies. Even in that situation where the person knowingly, intentionally purchased the home, but they didn't move to the home before that car accident, it cannot be exempt from the calculation.
That's correct.
Okay, I just want to make sure.
That's the way the federal law reads, and that's the way the department interprets it, because under the policy manual, which is developed in Florida to interpret federal law, it indicates that the person must have lived in the home before they apply for benefits. Must have lived in the home.
Why should we give any I'm sorry, go ahead, Judge Silverman.
Does it actually say must have lived, or does it say return to?
Must have lived. And that's in the record.
Go ahead, Judge Lucas.
I was going to ask, why should we give this manual any deference?
It's a good question. And
I get one every now and then.
the manual itself, again, is not the law. It's not the rule of law. The rule of law comes from the federal code, and we have to follow the federal code. And the way that the federal code is interpreted is looking at the plain language of that code. So if, again, you have to look at a principal place of residence is a place where someone lives. And the federal language indicates that a property ceases to be the principal place of residence as of the date that the individual left it with no intention of returning. So again, if you look at the plain language, if I leave my principal place of residence and I have no intention of returning, then it's an included asset. Okay, but I can't leave something that I never lived in. That's the whole argument here. It's unambiguous in the language. If I leave something, then obviously I must have been there before. Otherwise, there's nothing to leave. In this particular instance, she was institutionalized in a long-term care facility by the testimony of her own daughter and her power of attorney 2 years before the home was even purchased. And the home was purchased as a way to qualify for benefits that simply is not well-founded in law. Because again, if I take my assets, if she'd have done a personal services contract for the entire value of that home and turned that money over to her daughter, that's asset protection. The problem here is the daughter would have to pay income taxes on that because it would be income to her. So she paid income on the income taxes on the $154,000 that she spent down, but she doesn't want to pay income taxes on $400,000 that she used to purchase the home. You can't purchase a home, call it a principal place of residence if you never live in it.
Ms. Piccini.
It's all types of laws.
I was about to say, Ms. Piccini, Ms. Westmoreland, the code section that Mr. Piccini is relying on, or one of the provisions, is that an individual's principal place of residence is the dwelling the individual considers his or her established or principal home. And then it goes on to say, and to which, if absent, he or she intends to return. Is that the provision that you're pointing to?
I'm pointing to that, but I'm also reading it in its entirety, because under 416.12.12, under 20 CFR, the home, like you said, is any property in which they have an ownership interest and which serves as the individual principal place of residence. okay? The property includes the shelter in which an individual resides, the land on which the shelter is located, and related outbuildings, okay? The property includes the shelter in which an individual resides. The individual never resided in this shelter. So I can't count it as their principal place of residence unless they reside in it. In the 2 years leading up to her application for benefits, she was in a nursing home. The property was purchased in July of 2019, after 2 years after she was institutionalized, and then they wanted to claim it as homestead property. She did not reside, and the federal language is clear, and it's in the brief, it's in the appellee's answer brief on page 26. 20 CFR sections 416.1212 defined a home is any property in which an individual has an ownership interest and which serves as the individual's principal place of residence, includes the shelter in which an individual resides. You can't reside in something that you do not own. And if you own it after you've applied for, or you own, after you've resided in an institution, it cannot be your principal place of residence for purposes of Florida code because you did not live in it prior to applying for benefits.
Are you
Ms.
aware?
Westmoreland, I'm sorry, go ahead, Joe Silverman.
I was just going to say, are you aware of any authority? And I don't see any cited in here, but obviously you all have a lot of knowledge in this area, but has there been any interpretation that you're aware of contrary to the position that you're articulating today?
I'm not aware of any contrary position to that by cases or anything like that. I've done a lot of looking. I did find one case to support the department's contention. It is an Arkansas case. And essentially what happened is an individual executed a power of attorney in favor of her daughter. And the daughter then used that power of attorney to purchase a life estate for her mother in the daughter's own home in order to spend down the mother's assets. But the mother never actually resided in the home. She periodically stayed at the residence, visiting from the nursing home. And the court found that the purchase of the in the home did not constitute exclusion of the home for purposes of federal ICP benefits. And that is cited at 82 ARK.APP 447. It's Bernice Groce, Groce versus Director, Arkansas Department of Human Services. It's a June 11th, 2003 case.
Does that case turn on the fact at all that it's a life estate as opposed to outright ownership, legal title?
I don't believe so. No. It says the appellee pointed out that in that case, the appellee pointed out that the appellant overlooked 20 CFR 416.1212A, which I've read to you, which indicates the home is any property in which an individual has an ownership interest and which serves as the individual's principal place of residence. In this particular case, the appellant, the daughter, answered in the negative when asked if the appellant had actually lived in the house and received mail there. She testified that the appellant had never moved in the residence or taken up residency or given the nursing home notice that she was not returning from a visit. Occasional visits to the home after appellant purchased the interest did not convert the home into her principal place of residence.
Very good. Judge Lucas.
Ms. Westmoreland, I want to maybe switch gears over to the first issue on appeal, and it's kind of a two-part question. The first part of the question is, other than having an excess amount of assets, would there be any other reason for DCF to deny an application that's been properly filled out?
Sure, they could have too much income. Okay, income and assets are two different things. Income can be converted to an asset the month following the month that it's received, but you can have too much income, you can have too much assets. In this particular case, she was over the asset limit.
Right, I got that. Are there any other, besides too much income, too much assets, are there, if the application has been properly filled out, are there any other, would there be any other basis for the DCF to deny it other than too much income, too much assets?
Not that I can think of right off the top of my head.
Okay, and that segues into the second part of my question, which is reading 45 CFR section 206.10 sub 4 says, under this requirement, adequate notice means a written notice that contains a statement of the action taken and the reasons for and specific regulations supporting such action, and an explanation of the individual's right to request a hearing. Given that this is basic, this denial and this notice is basically the portal, the entryway to a hearing, to a contested hearing. What of Mr. Pachin's argument that, listen, you need to lay out more than that on the front end, other than what you've just told me are, there's only two reasons why you would deny this: too much income, too much assets. Well, that's not really a reason then. What of his argument that that's really just a conclusion? You need to give me something more. How did you conclude that this, that the assets were too high in this initial notice, so that, and I think the argument would run, so that we can have a meaningful hearing, so that we can prepare our argument beforehand? What of that notion?
Mr. Pachin makes the argument that the notice should have spelled out exactly which assets were too high. And in that particular case, that's not really a basis for a notice of case action. There's, like you said, there's two reasons that a case can be denied. You have too much income, you have too many assets. So the notice set out the provision in the administrative rules that led to the department's conclusion that the assets were too high. Because there's certain definitions of assets. You have cash, you have property. That's your assets. And so in this particular case, you've got an individual that has cash, she has a checking account, which counts as cash, and then you have a house, which is property. Those are the assets. If I were to have any other definition of asset, then I might buy his argument.
I don't know that you're quite getting what I'm driving at here. Which I'm just focused on what you all put in you are the masters of your notice that you give to these applicants. Given that you've just told us, look, this is a check the box thing. It's either too much assets, too much income. What else? The 45 CFR section 206.10 sub 4 has to mean something, right? And when it says you have to lay out your reasons for doing this, given that there's only two bases, I'll call them bases for denial, that it doesn't seem to add anything. If it's always going to be, the denial is always going to be either too much income or too much assets. What does the CFR here then add by saying you also have to lay out reasons if in fact what needs to happen is, as what I think Mr. Pachin would advocate, you need to lay out, hey, what is the how did you land there? What conclusion, what evidence did you rely upon? Why is that an unreasonable interpretation of the CFR here?
Well, it's not an unreasonable interpretation, but I would argue that we did lay out our reasons for it. The assets are too high. There's only so many things that you can own that can be an asset. And
I think we maybe just be going in circles a little bit. I think what he's arguing is, how did you get, show your work? How did in the initial notice, how did you reach that conclusion? I think that's what he is advocating.
And that's fine, but there's nothing in the federal code and there's nothing in the case law that says we have to, like an individual math problem, show our work and show each individual stuff that we got there.
Well, unless you interpret reason to mean analysis, reason.
The assets were too high. He knows what documents he provided.
All right.
It's just like the hearing officer said in her order. If his documentation was competent substantial evidence to establish eligibility, then it's also competent substantial evidence to establish ineligibility. He's the one that provided the documentation of what her income and assets were. Therefore, he knows what the assets are that we're looking at to determine that the assets are too high. He provided the documentation. That's how the department gets its conclusion, as you want to call it, that the assets are too high. We don't just go out and say, you have too many assets. They have to provide documentation verifying what the assets and what the income is. Assets are and income is. Sorry, my grammar, that was really terrible. But you understand what I'm saying. Just because
I understand what you're saying, I'm not sure it quite reaches what I'm driving at, but I do understand what you're saying.
Okay, but then let's go to your other point that you raised earlier, what's the harm? In the case that was cited in the brief, which is the Hopkins versus the Department of Human Services case, cited at 802 A second 999. Basically, if the federal court has determined that if you have the opportunity to hammer the issue specifically before you get to a hearing, then there can be no harm, even if you find that the notice is deficient. So Mr. Pachin had the opportunity for discovery. His own initial argument indicated that he did depositions. That's laid out well in the record, that he deposed the hearing unit individual who reviewed the case. She laid out the specific reasons for the denial in her deposition, the checking accounts, the home that's not excluded as a homestead property. And then we get to the hearing on it. The checking accounts, the home, those are the assets. He knew specifically what we were looking at. The argument was made at the final hearing that the outstanding checks that he's arguing was raised for the first time on appeal. That argument was made at the first hearing, at the initial hearing, at the hearing in April of 2020. Cannot count outstanding checks to spend down assets. First of all, they're not even tendered. The UCC, the Uniform Commercial Code, lays that out. If they're not tendered, then it's not an outstanding check, and you still have control of that asset. The ownership and control is what the department uses to establish the applicant's asset limit. If I have control of money, then it's mine to use however I choose to use it. If I give it to someone else, I no longer have control. I'm sorry.
Let me just let you know you've come to the end of your time. You can take a few seconds to wrap up with the conclusion.
Okay, I'm just trying to, argue or answer Judge Lucas's question, and he raised it on the first issue, which what's the harm? There was no harm because he had the meaningful opportunity from the time of denial in October of 2019 to the hearing in April of 2020 to find out the specific reasons on the asset value. So even if the court would find that the notice is deficient, which I would argue it's not, there is no harm because he had the opportunity to get to that basis before we had the hearing in April of 2020.
Very good. Thank you very much, Ms. Westmoreland. Mr. Pachin.
Yes, 2 points. To Judge Lucas's point, if you review the record and the deposition transcript in particular, the specific question was asked to the state's representative, which part of the section of the code that's referenced in the notice, which part of that code section did the appellant violate? And handed her a 6-page single-space replication of that provision and said, show me where in this section the law was violated. And the testimony was she couldn't do it. She specifically said, I don't know. Not only that, she came back and said the whole thing. That was a deposition that we had to fight to get, 2.5-hour deposition. That's the extent of the discovery in this case. That was the testimony at the deposition. I don't know. How are we supposed to know? If the state's own representative couldn't tell us and she doesn't know, how are we supposed to know? That's the first point. And to Judge Silberman, your issue with a person coming into the state, gets into a car accident, ends up in a hospital or institutionalized, we have a remedy for that. That's what this case is based upon. The Florida Supreme Court spoke to this issue 100 years ago and said mere preparation of the homestead is sufficient. That's good law. That law has been relied upon by bankruptcy courts. That's cited in the brief. We have a remedy for that. And we have a remedy here. That's the same remedy here. For a person that is stuck only because of her own health through no fault of her own, she's not living in that home. And the remedy is in the simple case. More than enough evidence has been submitted on the record to show all the preparations that she took to make that place habitable. And as a matter of fact, she even lived there. And when we asked the state, how long does she have to live there? The answer we got, she has to be discharged from the nursing home, which means she has to start incurring charges. We don't care how long she lived there. As long as she's still paying the nursing home, she can't reside in her home. That was the argument. We asked, how long does she have to live there in order to qualify? And we got no answer. We have no answer, but we have the simple case. We don't need that. To Judge Silverman's point, we have a remedy. The remedy is over 100 years old. It's just completely being ignored in this case. And to Judge Lucas, your point on the brief, and again, I apologize, I did not replicate the actual sections of the federal and state codes, but they are referenced in the brief on in the context of the first argument. All the citations are there, and I apologize. These briefs are mammoth. This is a regulatory brief. We had to be cognizant of the page length, and we just could not reproduce every single regulation. Now, the last point I just want to make is,
You've got 15 seconds to conclude.
okay, there are the state alluded to other measures that could have been taken to get disqualified. Chose to purchase a home because a home is essential for the emotional well-being of the individual. There are many other ways we could have done this. Wanted a home, and she should be entitled to that under the simple case. She is entitled to her homestead exemption. With that, thank you very much, Your Honors.
Very good. Thank you, Mr. Pitching and Ms. Westmoreland. The next case on the docket is Huston and BTL Industries versus Sinosure and Lotus Parent. For planning purposes, after this next case,